Welcome to the Great Divorce Podcast, hosted by divorce financial analyst and retirement planning counselor Andrew Hatherley. Join Andrew and guest experts as they help late-life divorcees build the financial and mental foundation for a meaningful future. There is life after divorce. Now, on to the show.
Hello, everyone, and welcome to the Great Divorce Podcast. Few people outside of divorce professionals and people going through divorce know what a QDRO is. Well, a QDRO, or QDRO, is an acronym for Qualified Domestic Relations Order. A QDRO is an order used in a divorce proceeding for a retirement plan to pay a spouse or a former spouse his or her community property rights in a retirement plan. QDROs are fairly simple documents, but they can be tricky to prepare. And for that reason, it's important to use a professional with QDRO experience. Well, we're fortunate to have just such a professional with us today. Shann Winesett is a certified family law specialist with the Pecos Law Group in Las Vegas and is licensed in Nevada and California. He attended Loyola Law School in Los Angeles, where he earned his Juris Doctor degree in 1993. And Shann also operates Las Vegas QDRO, a firm that assists litigants and attorneys across the country in dividing retirement assets in divorce. I should note that Shann, like myself, is a member of the Amicable Divorce Network, an association of licensed professionals dedicated to helping reasonable people navigate the process of divorce. Shann, welcome to the Great Divorce Podcast.
Thank you, Andrew. And thanks for having me.
You bet. Now, I briefly touched on what a QDRO does in my introduction, but you're the expert here. Can you tell our listeners what a qualified domestic relations order is and why it's necessary in divorce?
What it is an order that is necessary to divide qualified plans under ERISA. Traditionally, retirement plans have been exempt from execution. So retirement plans would not permit anyone to execute upon the benefits. So the laws were implemented to allow a former spouse or other qualified person to obtain those benefits. And in order to make it enforceable, it has to have an order issued from a court from a domestic relations dispute. So basically, what the Qualified Domestic Relations Order is a directive that, once qualified by the plan, is binding upon the retirement plan to disperse otherwise protected funds to a former spouse, child, or current spouse.
Okay, well, a couple of things I want to bring down to layman's terms here when we talk about ERISA. ERISA is a fun word for retirement geeks like me and certainly QDRO experts like you. And it stands for the Employment Retirement Income Security Act of 1974. And you mentioned ERISA plans and qualified plans. So it's important to note here that not all retirement plans are divided by QDROs, right? And this can be a problem.
That is correct, because sometimes there'll be retirement plans that are not qualified plans, and they don't care what a divorce court says. They will or will not, based upon their plan documents, respond to a divorce court's directives on how to divide that asset. Also, they can, even if they are going to disperse funds from a retirement plan, they may not do it on the time frame or the time set by the parties or their expectations. So it's important, before a divorce decree is entered, that the parties know what kind of plan they're dealing with before they endeavor to divide it.
You mentioned timing. Yeah, I mean, timing is a crucial issue here. The QDRO should be done, should it not, before the divorce decree is entered, particularly with pension plans?
Yes, absolutely, because at least in Nevada, it's the decree that is the operating document to tell how the asset is to be divided. And so the QDRO itself is not supposed to modify or alter the decree in any way. It's supposed to implement the terms of the decree. So if you're planning on dividing the asset, you're going to want to have the qualified domestic relations order prepared at the same time as the divorce settlement, so that the parties are all on the same page as to what is going to happen. Because at that point, you can alter the terms of the decree to make sure that the parties' desires in dividing that asset are fulfilled.
Now, you raised some interesting logistical issues here with respect to the timing and how the QDRO is done. Might as well deal with that now, since we brought up the subject, and then we'll get into some of the specifics on dealing with QDROs in typically 401ks and then defined benefit or pension plans. But I've seen that there can be some issue. I've seen it in my practice and with attorneys such as yourself who do QDROs I've spoken to, that there can be some logistical issues. For instance, failing to stipulate who's going to do the QDRO and then even implementing it.
Well, that is correct, because most of the time it's not surprising that the parties to divorce litigation are not cooperating. They're not happy with each other. And so oftentimes divorce lawyers won't clearly divide the retirement benefits. They just have some vague language in the decree, and then it says, oh, the parties need to jointly retain a QDRO preparer to do the QDRO. The problem with that is, if the decree is vague as to how the asset is to be divided, you don't have the QDRO preparer doesn't have the control, because now the case is over, the decree's entered. The QDRO preparer cannot force one party to produce documents if they're not willing to do, and if they're not cooperative, or they start fighting about the language of how the retirement is to be divided, logistically it becomes difficult for the QDRO preparer, because the divorce case isn't open.
So the two attorneys need to establish, how this is going to work in order to get it done before the decree.
Yes, and they should probably, if they don't have a fluency in how retirement plans are divided in divorce, and as we've been discussing, the retirement plans can be very different depending on what kind of plan it is, whether it's the defined contribution plan like a 401k, or a traditional pension, or military retirement, or something like that. If the divorce attorneys don't have a fluency in dividing those assets, they should communicate with someone that does, so that the decree can be very clear on what has to happen. So then after the decree is entered and the parties are divorced, the domestic relations order can be implemented consistent with what the parties expected at the time of the divorce.
Certainly. I mean, bringing professionals such as yourself with experience in QDROs in is so much to the benefit of both the parties, so that they ultimately emerge from the divorce with what they expect and have agreed upon. And for the attorneys themselves, I mean, I can see potential landmines sitting for years and years and blowing up in malpractice cases when, for instance, one of the parties retires and all of a sudden the pension payout begins in terms that weren't agreed upon, but because the QDRO was improperly prepared, the parties and the attorneys could find themselves in a world of hurt.
That's absolutely correct. And oftentimes the decree gets entered. I'm often dealing with decrees. I'm even dealing with a decree that's 20 years old, multiple, over decades old, and it's problematic for the parties and the attorneys that actually drafted the original decree. And when I do lunch and learns with attorneys regarding QDROs, I often let them know that the malpractice in dividing the pension occurs in the decree, not the QDRO. because the decree, again, is the operative language. And a lot of attorneys seem to think that we'll just identify the retirement in the decree, and then the QDRO preparer will wave a magic wand over the decree, and suddenly the assets divided as the parties imagined it. But that's not how it works.
Well, let's look at where QDROs are typically used, and we've mentioned defined contribution and defined benefit plans. We should mention at the outset that we're typically with defined contribution plans, we're talking about 401ks. We're not talking about IRAs, though, are we?
No, not at all. The IRAs are they're self-funded. Obviously, you're contributing into that account with some tax-deferred benefits. But when you're dealing with other types of retirement plans, those that require qualified domestic relations order, you're actually dealing with an employer-sponsored plan, like a pension, military, state-sponsored plan, or 401ks, which are sponsored by the employer.
So let's look at 401ks first. I would imagine that in this world where pensions are increasingly scarce, you're probably dealing with 401ks more often than pensions.
Yes. 401ks are more common. The traditional pension, because they're so expensive to maintain by most employers, pensions are becoming less and less common. Obviously, your major pensions, your state-sponsored pensions, or like the union pensions, are still there, but you don't see many employers or companies creating pensions for their employees anymore.
Right.
It's much easier to create a 401k plan, which with tax deferred savings, where the employee takes the risk of the fluctuations in the market, as opposed to the employer guaranteeing a specific income post-retirement.
Well, let's look at both, but let's look at the defined contribution, or typically the 401k plan, first. And I want to talk to you about some of the best practices to avoid road mines or land mines down the road with 401ks and QDROs. And one thing I want to start with was earnings and losses, because you've got to date the QDRO, but it's never actually split. It's never enacted exactly on the date of decree or when it's entered. There's going to be a time lag here. What's the best practice for dealing with earnings and losses?
The best practice is in the decree is to make sure to address whether the alternate payee's share of the retirement plan is subject to the gains and losses in the account, which would be consistent with Nevada's community property principles, because the return on investment of community property is community property. The return on investment of separate property is separate property. So if the decree is silent to those gains and losses, or in particular, if the decree merely says that the alternate payee will receive $50,000 out of the participant's 401k, and that's all it says, then the question is, well, is the alternate payee supposed to receive a specific sum, a flat amount of $50,000, or is that $50,000 subject to gains and losses? Now, if everyone's doing their job and the QDRO is entered at or close to the time of the divorce, that's not going to be a problem. But if the QDRO isn't addressed until 5 or 6 years from the date of the divorce, then if the market had gone up, the plan participant is going to say, no, she's only entitled to 50%, or excuse me, $50,000. So that's the importance of, if the decree itself references the gains and losses, then that's not subject to debate.
And I've seen that. I've seen a case where the spouse who's to receive half of her husband's QDRO did not begin to enact it until 6 years after the divorce, which was beyond my comprehension. But I know In divorce, we sometimes have what's called divorce brain, but I would have thought that sometime in the intervening 6 years it might have been addressed. But these things happen. Another thing that happens with 401ks, which can provoke some problems, is the issues of loans, because participants can often take loans from their 401k. But in a divorce proceeding, it's important to, well, you tell me, what have you seen with loans, and what we might watch out for there?
The loans is another thing, because the interesting thing about loans is that the plan administrator, when it looks at a 401k plan, for example, and there's a $20,000 loan against it, the plan administrator will look at that loan as an asset of the plan. So if you had $80,000 of investments and a $20,000 loan, the plan administrator is going to look at that account as having $100,000 in assets, because the plan administrator looks as a loan not as a liability, but as an asset in the account. And so when you're dividing that and you don't address how the loans are to be divided, and you say 50% of the account value, some plan administrators will look at a $80,000 investment plus a $20,000 loan. They'll divide it in half, meaning the alternate payee receives $50,000, not $40,000. So it's very important to address the loans. It's also, and that's very important also because between the entry of the decree and the entry of the QDRO, the 401k account is not frozen unless someone lets the plan administrator know that it should be frozen. So you can withdraw money as the participant, or you can take loans against it.
Well, that could create a real can of worms.
Yeah, yes, it could. And I'm dealing with that type of thing right now as well.
Can you divulge without harming the innocent?
Let's just say theoretically, a plan participant is required to buy his equalize through a $50,000 payment to his wife. The decree, the case gets settled, the decree gets entered, but the QDRO isn't prepared until later. Between the time of the entry of the decree, a $50,000 loan is taken out of the 401k, and now there's no enough assets in there to pay the alternate payee, and the alternate payee has now been paid an equalization payment with her own share of the retirement benefits.
Oh my goodness.
Yeah.
Yeah, that's not good.
And as I referred to before, the parties preparing QDROs typically, unfortunately, do not like each other, and they're not cooperating. And so there's a selective memory that takes place in drafting QDROs. If the decree isn't articulating what needs to be done, they certainly will interpret what was supposed to happen in the way that's most beneficial to their financial interests.
Of course they will. So I've come across a situation. I'm curious to get your thoughts on this, Shann. Typically, and I'm sure our audience is probably asking themselves right now, how much does this QDRO cost? So what's the typical cost of a QDRO?
We do a flat fee of $900 per QDRO, and that covers from communicating with the plan administrator, getting the decree, preparing the QDRO, and we always submit it. Any company that's preparing QDROs will always submit it to the plan administrator for pre-approval before it gets submitted to the court for entry as an order, because the plans always have a need to tweak it to make sure that they're interpreting the QDRO consistent with the plan documents. And so part of the process is to prepare the QDRO, submit it to the plan for pre-approval, get the pre-approval, submit it to the parties to review, accept, and sign off, then submit it to the court. Then get a certified copy, send that to the plan for implementation. And that's the process of what we do in preparing QDROs.
Okay, well, there's quite a lot of work involved there. So
Yes.
let me run a situation that I've seen. I don't know how common it is, but I'm sure it happens quite frequently, where one of my clients came to me, and there were 5 QDROs drawn up on 5 different 401ks, but some of the 401ks were literally less than $5,000. So essentially, nearly 20% of the value of the 401k was being lost through the QDRO. To what extent does the need for a QDRO supersede maybe equalizing the assets in a way that they can be split by perhaps the tiny 401ks can be kept in the individual participants' names, and the maybe one larger QDRO can be divided.
You can do that to cut costs on preparing the QDRO and cut the time and expense of processing multiple QDROs. But again, it kind of boils down to knowing what it is that you're dividing, because every retirement plan is going to be invested in its own special investments, and it's gonna have a rate of return determined depending on its investments. And so the only risk that you have in doing kind of an equalization is one of the parties might be losing out on a plan that was either hit hard with losses for some reason, or one plan that is really generating income. And that depends upon when you equalize, what date you use for the evaluation, because once you equalize, then the party that has the small accounts is going to receive those. They're going to be generating income based upon their respective investments. And the big plan that you're using for the equalization is going to have a different level of return on investment. And so that's the only disadvantage, is that it's hard to predict who is going to, if someone gets a windfall, and it could just be, it could be negligible, but depending upon how the plans are invested, it could be significant sums, depending on how much money you're dealing with.
Well, good points to consider. Let's look a little bit here in the time we have left at defined benefit plans, or as we commonly refer to them as pensions. And let's start with a pension that's already in pay status. One of the participants is getting a monthly check. How would a QDRO deal with the division of that payment?
The QDRO typically would use what's called the time rule. At least in Nevada, that's what they would do. And the time rule, what it does is it creates what it's called a coverture fraction.
Right.
So the coverture fraction, the numerator of the fraction is the number of months or credits applied to the pension during the period of coverture, during the marriage. The denominator of the fraction is the total amount of credits or hours or months, however the plan calculates its benefit. And that amount is divided by half to get the alternate payee share. So the coverture fraction is designed to capture what would be the community share. And then the alternate payee receives 50% of that amount. And if the pension is already in pay status, then the plan participant, probably in conjunction and communication with the spouse, has already determined what, if any, type of survivor benefits are going to be received if something happens to the plan participant after retirement.
Well, you're reading my mind, because that was my next question: is how would you deal with that with a pension? But if it's in pay status, it's already been dealt with.
Correct.
Okay, so let's look at a situation where a pension's set to be paid out in 10 or 15 years upon the retirement of the participant. How would a QDRO address the issue of survivor benefits there?
It would determine the community's interest again by the coverture fraction that we discussed. But then the plan can create what's called a separate interest division of the retirement, which will then, the plan based upon when the participant reaches the first eligibility for retirement, then the alternate payee can at that time select a payment or select the income stream to begin, the retirement to the alternate payee to begin. So what they will do is they will apply the portion that the alternate payee is to receive, and then actuarially adjust that payment based upon the lifespan of the alternate payee, and then that stream of income will start. Once that starts, then if something happens to the participant, the alternate payee will continue to receive the alternate payee share until the alternate payee passes.
This would seem to me to be an ideal situation because it would give both parties control over how their benefits are paid and eliminate the alternate payee's risk of payments ending on the participant's death, right?
Yes, that is definitely beneficial to the alternate payee. The only time you would consider what's called a shared interest approach is if both parties were in cooperation and you expected the alternate payee's lifespan not to be very long, and the parties were close to retirement, so that if the alternate payee predeceases the participant, that there would be a reversion of the alternate payee's share back to the participant. But of course, that will require goodwill and good faith and cooperation among divorcing parties, which sometimes can take place, especially at that age. There's other reasons why people get a divorce beyond irreconcilable differences.
Sure. And one would hope that we would see more of those amicable type of cases where
Yes.
people get more educated about the divorce process and realize it doesn't have to be 9 months of living hell necessarily.
Correct.
So you mentioned the coverture fraction and the time rule as applies to the dividing of defined benefit plans, but it's different with defined contribution plans.
Yes, and that's a mistake that both judges and divorce attorneys make all the time, that they just say, okay, the 401k will be divided by the time rule. But the time rule really doesn't apply very well to defined contribution plans, because, for example, you don't know when the contributions actually took place. Just because you were working for a company doesn't mean you were contributing to the plan. Also, you might make decisions after your marriage not to contribute at all. So, for example, if you have a spouse that had $50,000 at the time of marriage, and that spouse says, you know what, I've got a lot of expenses now in this young family that I've got, I'm not going to contribute right now. And that decision kind of just stays that way for the duration of the marriage. If you apply the time rule, what would be separate property belonging to the spouse, that $50,000 pre-marriage, belongs entirely to the spouse that earned it, but it would be divided under the time rule, and you could get a significant share of that being given to the person that really has no interest in it because it's not community property.
You know, there's what you just said just points out the potential landmines and pitfalls involved in having QDROs done by people who aren't well experienced in the drawing up of these orders. Shann, if any of our listeners or any of the attorneys listening to the podcast are interested in finding out more about your services, which you do offer across the country, correct?
Yes, I do.
Terrific. How can they get in touch with you?
The company is LasVegasQDRO.com, and they can just get in touch with us through our email address.
All right, LasVegasQDRO.com, and I will put the link to your website in the show notes on the website transcendretirement.net. Shann, Thanks very much. It's been very illuminating discussion.
My pleasure, Andrew. Thank you so much for having me. I enjoyed it.
Thanks so much for tuning in to this episode of the Gray Divorce Podcast. To learn more or get in contact with your host, you can visit Andrew's website at transcendretirement.net. Also, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show, and we greatly appreciate it. Thanks again for listening, and we'll catch you in the next episode.
Information provided is educational only and should not be construed as legal or tax advice. Each situation is unique and should be discussed with your tax or legal advisor prior to implementation. Andrew Hatherley is not an attorney and does not provide legal advice. Information provided is financial in nature. Advisory services offered through Hatherley Capital Management, LLC. Divorce financial analysis services offered through Wiser Divorce Solutions, an affiliated company.